All right, I've just put up some slides there. That's the Melbourne Activist Legal Support Group logo. I should say this morning's not an official MALS event, but I have put together some resources that they regularly use for these sessions. We sort of deliver them in different formats. If this is useful to you this morning, we can certainly organise a longer training at a later date. I'm just having some technical issues. Let's try that again. Trust the young person here to struggle with the technology. Here we go.
You are
all
the
right.
young person.
So that's me. MALS is, you may have seen us or not, but certainly we're there as an organisation to provide legal observers to events. We've worked with XR in the past. We work with, we're always there at the Invasion Day rally. We're there at the Black Lives Matter rally. We don't make it to every event. Usually there has to be some decision about resourcing, and we only go to events where we're invited to attend. We also publish statements of concern about police tactics at protests. Particularly, we've been concerned recently about the use of projectile weapons. We've seen in response to the anti-lockdown rallies, regardless of what you think of the people who are turning out for those events, police sort of deployed paramilitary style equipment in response to that. And it's among the community, I suppose there's a grave concern that police will continue to use those sort of tactics at protests in the future. So it's something we really need to be on the lookout for as we move out of lockdown into Spring Rebellion or other events, particularly, for example, the Invasion Day rally. We're concerned how police will respond to that. As I said, we provide training to other groups. So if this is useful, or if there are aspects of this presentation that you want to know more about, just let me know. So just briefly, I know this is a bit esoteric, and you're probably more interested in how police can interact with you on the ground on the day of an action. But just to cover, I suppose, the ground, there is a framework in Victoria. We do have a Charter of Human Rights and Responsibilities that includes the right to freedom of assembly. We're fortunate in Victoria that we have specific legislation to protect those rights, including there is a right to implied political communication under the Constitution, but it's a long way off to point to that. At least in Victoria, the police have to plan their behaviour in accordance with the legislation under the Charter. So I've provided a couple of handouts that we can send around to participants in relation to how police exercise their move-on powers or how they police demonstrations. And those documents, it's from the internal police manual that Victoria Police are guided by in their day-to-day operations. And those documents refer specifically to the rights under the Victorian Charter. So police are aware that we have these human rights as people within Victoria. You don't have to be a citizen of the state. If you're an individual human in Victoria, you're entitled to the rights that are under that legislation. In terms of human rights, I'll just say that they're generally something that acts retrospectively. I've never seen somebody at a protest sort of talk their way out of being arrested by claiming their rights are being infringed. Usually what will happen is there'll be an investigation long after the fact. For example, with the tower lockdowns, the Victorian Ombudsman found that the Victorian state government did breach the Charter, the Victorian the Charter of Human Rights and Responsibilities. There's been no consequence to that finding. Essentially, the Victorian government has still refused to apologise for breaching the human rights of the people who lived in that building. Now, on the day of a protest, police are, I guess, exercising legislative powers that they've been given through legislation that governs the state, as well as what we see under the Crimes Act. Recently, police have been exercising powers under the Public Health and Wellbeing Act, because we've all been under lockdown, those powers under the chief, through the chief health officer's directions, have really been the go-to in terms of what police have used. Many of those powers only result in infringements that have that are what are called infringements, penalties that are infringements. So they don't result in criminal penalties beyond that. But generally, outside of pandemic conditions, what we see is police using their powers under the Crimes Act. Now, in terms of how you think about taking care of yourself and interacting with police on the day of a protest, police powers generally rest upon a suspicion, a belief that police form that you've committed an offence or that you are likely to commit an offence. And if police have those beliefs or claim to have those beliefs that you've committed an offence or are likely to do so, they're empowered to do certain things. They can ask you to identify yourself, and they can, depending on the gravity of the offence, they can potentially ask to search you. There's a phenomenon that police occasionally use where they can designate a specific area under the public, I think it's public, oh no, it's the Control of Weapons Act. And if an area is designated, it has to be published in the Police Gazette ahead of time. And what that means is police can essentially ask your name or search you without having that reasonable belief that you've committed an offence. Police, the offence that police can claim to believe you've committed can be something very minor. It can be a summary offence, for example, criminal damage. I understand some people in this group might have been arrested for chalking outside offices, chalking slogans on the pavement or something. In my opinion, that's not an offence because there's no criminal damage caused. But generally what police are doing now is talking about breach of Chief Health Officer's directions. Now that lockdown's ended, it should mean that police don't have that as a go-to. They can't say, well, you're not outside for one of the approved reasons. So it may well be harder for them to effect arrests in that kind of situation. I should say, well, I've got a note about Section 138 of the Evidence Act there. Essentially what that means is if police obtain evidence about you that's unlawfully obtained, if they search you without a proper legal basis for doing so, then that evidence can be excluded if you go to court and you're arguing about whether you did commit an offence. If the police have acted outside of their powers, acted unlawfully, then they're not able to rely on that evidence at a later time. But that's all long after the fact. Once, you know, if you have been charged and then if you're fighting the charges in the court, which might be months and indeed years after a protest event. So in terms of the rights that you have as protesters on the day, you have a right to know which police you're dealing with. Every member of Victoria Police has to identify themselves on duty, and that's a requirement under the police manual. If they ask you what your name is, if they require you to identify yourself, you're entitled to know why, what suspicion they have, or what offence they suspect you of having committed. But then beyond that, if they ask you to identify yourself, you have a right to know exactly who they are, and you can ask for their name, rank, and their station. It's good to take down those details, even just as a matter of practice generally, because it puts police on notice that they're being observed, that you know, that makes them aware that you are aware of their obligations in conducting themselves. If you are arrested, you have a right to speak with a lawyer, communicate with a friend or family member. If you're not a citizen, you can speak with an embassy. But beyond those rights, generally what police will do is try to, I guess, save resources by encouraging you to confess to whatever offence you've committed during a record of interview. As a defence lawyer, we spend a lot of time in this job just advising people to make no comment interviews. And the reason for that is essentially that it's not really in your interests to help police do their job once they've arrested and charged you, if they've got evidence they think they can establish an offence with, that's fine, but there's no need to assist them. Although I appreciate that does change depending on your reasons for protesting or indeed being arrested. In terms of searches, if you identify as female, you have a right to ask to be searched by an officer, a female officer. So you can make that request, and that's within the police manual as well. Now, in terms of this point, what I would say is I'm very impressed to see the network this morning that's turned out. Networks such as these are really the key, I think, to building confidence and helping people exercise their rights, the political rights that we do have. It's important, to take care of one another, to debrief after events, because they can be extremely stressful. What I've got down here is probably more relevant to legal observers, but certainly I would encourage, and maybe Rob would be able to speak to this, I'd encourage having someone there who is filming police and observing what they do. You would have seen, all of us have seen the impact that footage of police behaviour can have on the political conversation, or indeed in holding police to account. We all have mobile phones, in our pockets now that can film police conduct, and they have been the single greatest tool in holding police to account in terms of them acting violently or outside of their powers. So if you don't have a designated legal observer group present, then certainly have someone filming. It's useful to have an independent group, because they can claim that they're not, they can assert that they're not taking part in the protest, that they're merely there as observers. So police are sort of constrained in the way that they treat them. Complaints are an important part of the process, but as with criminal charges, there's something that happens long after the fact, months or years down the track. And the best approach to that, I suppose, is if police have acted in a way that causes you to make a complaint, to really marshal the evidence of that. Video is the strongest thing, strongest piece of evidence you'd have there, but also perhaps notes. Police rely a lot on contemporaneous notes in proving the charges or their version of events in court. Any individual has the same advantage if they wish. Write down an account of what's happened, who was involved, where it happened, when it happened, sign and date that account, and just keep it in your file, because you never know when it may come in handy later on. Even if it's not a complaint that you've made, it might be a complaint that another participant has made and they need supporting evidence. In terms of police accountability, this isn't directly relevant to the day of the protest, but I'd encourage you all, if you're concerned about the behaviour of Victoria Police, to follow up these resources. The Police Accountability Project associated with the Flemington Kensington Community Legal Centre is a really useful resource. They've got a lot of information that would benefit you, but they're also very interested in mapping how police are approaching protest events, how they're dealing with protesters, changing trends and so on. IBAC is fairly useless in terms of investigating police. I was able to find details from their report. So most police investigations are handled internally, and most of them find that there was no police misconduct. IBAC generally refers matters back to Victoria Police or dismisses them. So I think, yeah, in one financial year out of 3,600 allegations, 16 of those were investigated. Those are some resources that hopefully would be useful. COVID-19 policing probably is still useful. The handouts that I've sent to Serena involve common charges that you might face attending a protest event, and then description of common police tactics. You're probably all familiar with those already. And then 2 chapters of the Victorian Police Manual regarding their move-on powers and their instructions for how to deal with protest events. Having said that, before I move on to questions, just as in terms of my personal experience, it's very rare that someone would be arrested and charged at a protest event if they didn't intend to be arrested. Generally, police are reluctant to deploy the resources needed to arrest everybody at an event. I, had quite a, my parents weren't political activists. I had a sort of sheltered middle-class background. I thought when I started working with Mals that perhaps if I attended a protest event, I might be arrested accidentally or get caught up in things, jeopardize employment or other things in my life. But my experience is that protests that I've attended without fail have generally been safe events. They haven't put me at risk of being arrested or charged. And in terms of what I've observed, people who've been arrested at protest events in Victoria that I've attended have either made a conscious decision to be a bunny, to exercise non-violent resistance, or they've been involved in a physical altercation with a police officer where they've displayed some aggression. So I'm not sure if everybody on the link has attended a protest event, but certainly what I want to say is to encourage and congratulate you all for organising. It's often protest events can be a great celebration of people power. People there are concerned citizens exercising their civil political rights. You shouldn't be afraid. It may well be different coming out of lockdown depending on the numbers. Generally, what I'd say is there's safety in numbers at a protest event. The more people you can get along, the harder it is for police to arrest or charge individuals. But even at small events, my experience is that police will generally give a series of warnings before an arrest is made. I'm happy to speak about the process after an arrest is made or charges are laid, but at this stage, I think I'll throw it open for questions because I've probably been speaking at you for too long.
Tom, just wondering, thanks heaps. So our first question in the chat was about fines, people being fined under presumably the Public Health and Wellbeing Act.
Yeah.
For chalking or wandering around in dresses with banners written on them. And and some quite large fines have been handed out by police.
Yeah, I think Victoria's got the heaviest fines of any state in Australia. Usually it's around $1,600. If you've been given an infringement, I suppose there are a number of pathways you can take. You can certainly, infringements are reviewable, so you can ask to have that infringement reviewed. I think from what I've seen that there's almost a blanket refusal to withdraw infringements issued under the Public Health and Wellbeing Act. In terms of referring it to court, that's a path that lots of people have taken. Once you do that, it essentially elevates it from an infringement to a charge that's progressing through the court. I've just seen a comment of 5,500 for exercising an address. So I would encourage people to refer those fines to court, really as a way of asking a magistrate to have some input into penalty. Perhaps I'll say it this way, that's all a bit confusing. If I were to receive a fine, the first thing I would do is ask for it to be reviewed, use the review powers within the infringements process. If that review was not accepted, I would then ask for the matter to be referred to the magistrate's court. Along the way, I would be seeking legal advice and trying to determine whether I was guilty or not guilty of the offence. The legislation is usually fairly narrow and it forces you from a very early stage to say, I'm guilty or not guilty. So it really forces you into those two options right from the start. I speak to a lot of people say, well, I was there, but I was there for this reason. And they feel that they're not guilty for that reason. But criminal law is sort of genius at just reducing things to basic elements. In terms of the liability for those types of offences, if the elements of the offence are there that you're out without an adequate reason, it'll be very hard to convince a court that you're not guilty. But what you can say is a lot to say in mitigation, and also a great deal to say in terms of the excess penalty that's been applied for those offences. So it's very difficult to see a magistrate upholding that as an appropriate fine for that type of behaviour, or what's described in the infringement notice. I have spoken to groups who are interested in mounting what's called a necessity defence. I'm not sure if that's something any people present have heard or thought about, but what I will say about that is it's never been successful before in Australian courts. It has been internationally. It really depends how much time and energy you're interested in devoting to the court process. Some people wish to use court as a platform, I suppose, to further express their political views and to communicate that publicly. You know, we have open courts in Victoria. Most of them running online at the moment. So certainly courts can be observed by people dialing in. But yeah, it really comes down to personal decisions, and it's difficult to give general advice about how someone should deal with an infringement like that, because it depends on their circumstances, what they want to do, also what the elements of what's described in the infringement. So what I would encourage anyone who's received an infringement to do is to reach out and seek legal advice, perhaps first through a community legal centre, through Victoria Legal Aid, general advice clinics, those sorts of things. So sadly, with a lot of questions that people ask to lawyers, I have to say it depends. But as a general comment, I would say that we've seen Victoria Police really using those powers as a way to intimidate people, prevent protests, discourage people from exercising their civil rights. It's been difficult during the pandemic period to be too hardline or firm about that because of health crisis in the community. But now, as we move out to that, with protesters who are fully vaccinated, police who are fully vaccinated, and without the restrictions on people's movement, it will be interesting to see if that changes the landscape. Presumably, they'll have to stop issuing these types of infringements.
Thanks, Tom. So the next question is about what happens if you refuse to be photographed?
I don't know how you would do that. So police have an evidence gathering team, and they're there pretty much every major event. You may have seen them, uniformed police officers walking around with a camera on a stick. They take footage of every protest event that I've been to that's significant. What we suspect, but have never been able to confirm, is that Victoria Police are engaged in face recognition, and that they build a database of regular attendees at protest events. So they haven't confirmed that. We haven't been able to get that on the public record through freedom of information or anything of that nature. But you would have seen stories recently about, I think there's a company, Clearview AI, which is able to take someone's photograph, run it through a program and match it to any social media profile. So what I would say is that if you don't want to be photographed, wear a mask. That's really your best option. But there's nothing you could do legally to say, don't photograph me.
I think, sorry, Tom, the question was more about when you get to the police station after you've been arrested. Yeah. I think we understood that you did have a right not to be photographed.
Okay.
But perhaps, police don't always follow that. So do you have any comments on that?
Or I don't know if my comments will be helpful here, because I've never before come across someone asserting a right not to be photographed. I have come across the situation where someone refused to identify themselves and were held in custody as a result. Victoria tends to follow an approach where if they can't establish the identity of someone, they will generally hold them in custody until they can. But that's very different to other jurisdictions, for example, the Northern Territory, where they often won't be able to establish people's identities and will generally just issue them with a fine or short period in custody before being released. I guess I'd have to take that question on notice. During interview, police will generally record an interview. If they're interviewing you at the police station, they'll generally seek to identify you. I'm not sure what specific rules there are around photographing, but I've never come across a case in which someone refused to be photographed and was successful. And I'm not sure if they have otherwise identified you through your name or other details. I'm not sure what advantage that would give you.
So Rob, you've got a comment on that, I think?
Yeah, it was part of the legal training that we were telling people quite early on that you do have a right not to be photographed when you're being processed within a police station. I asked them when I was arrested at Richmond Police Station, and they didn't really give me the choice. They just said, "Okay, stand here." And I realised at that point that they were about to take my picture. And I said, "Do I have the right to refuse?" And they said, "Yes, you do." And so I kept walking. Having said that, there have been other rebels who've also heard that information and attempted the same thing and been refused and had their photo taken. I guess it really, from my personal point of view, yeah, you do get video. The video quality is crap, but it's another data point that the police have. And so I was pushing back at that point to make sure that they didn't have a good quality photo of me. Like, it's not a big deal if they did or not. And I think any of these issues come down to a personal one. You know, how much power do you have in that at that time when you're dealing with the police? And it's really, is it worthwhile pushing back at that point, given that they have a hell of a lot more power than you do when you're standing in a police station? So it is very much a personal choice. But my understanding is that you can refuse to have your photo taken, whereas having your fingerprints taken, you cannot refuse, and they will physically try and take them if you don't comply.
So I think we've got another comment from Jeanette in the chat, but what I'd like to do is keep moving because there's quite a few questions. So Tom, maybe we could follow that one up. What is actually?
Yeah, I'd be happy to try and find the piece of legislation or the police manual on that point. And if I forward it to you, perhaps you can distribute it to.
Sure. All right, cool. So the next question is about, it's kind of got two elements. So the right to be searched by a female officer if you're a woman, or a non-binary person if you're non-binary. Do you have any comments on that?
There's certainly the right, well, I'm not sure if it's a right so much as a piece of the police manual that indicates that you have the right to request to be searched by a person of the same gender. I think it would be difficult. Victoria Police do have LGBTQI liaison staff, and certainly you could make a request with them if you're a non-binary person to ask for a person who's non-binary to search you, but it may be difficult. Or often they will talk about the practicality, or there are provisions under the manual which say as far as practicable or something of that nature. But certainly if you are female identifying and you'd feel more comfortable being searched by a female officer, you should make that request. And I would expect that Victoria Police would comply with that request. Beyond that, it's difficult to say what sort of requests you can make on that issue.
So can I just also, sorry, where would you be held?
Well,
if you were taken?
Yeah, Victoria is a real laggard in that respect. Okay. Basically, people are held in custody determined by their sex at birth. So we have a lot of women in Victorian male prisons, and it's really a shocking situation at present.
How do they prove that? Do they look at your genitalia?
Well, I think they go off people's bureaucratic sex identification on their license.
But that's not actually determined either. So how do they determine it? sorry to be stickler
No,
with
no,
this, but it's a real issue for me. Like,
of course, yeah. I mean, what I understand is that most people's driver's licenses will indicate their sex, and Victoria Police will make the court system, Corrections Victoria, will make their decisions based on that.
Right. Okay. So it's a guess, in other words.
Yeah.
Yeah. Okay. Cool. Thanks.
Thank you. Okay, so just moving along to questions about visas. The questions are about the impact on people with permanent visas.
Yes, and there are requirements under the Migration Act. Well, there are powers under the Migration Act where people can have their visas cancelled. There's a requirement that if you receive a term of 12 months imprisonment or more, I think the minister is required to review your visa status, but there's also a question under the Migration Act if you pose an ongoing risk to the safety and welfare of a member of the community, there's a power to cancel your visa. I would never expect those powers to be exercised in relation to someone who's attending protest events. There's nothing in that behaviour that would suggest to me that you're I think would suggest that you're a greater risk to members of the community, and in fact, it may well be that you're trying to reduce the risk to other members of the community through your actions. There's, of course, if your visa is cancelled, it can be reviewed. That decision can be reviewed in the Administrative Appeals Tribunal. You would be extraordinarily unlucky if your visa was cancelled due to attending a protest event. I don't want to say it's impossible, because we see Department of Home Affairs doing outrageous things regularly, but I think it's near impossible that attending a protest event would have that impact unless you had other criminal history, unless you'd been charged with other things, started receiving terms of imprisonment for other types of offending, particularly violent offending, family violence, those sorts of things.
Thank you. So the next question is about liability for costs associated with, and it relates to a question about, well, does that mean I should think about if I've got a house, moving it out of my name, or I've got a asset?
Yeah, I mean, I think that would be, I think that's unnecessary. In terms of liability for costs, the state generally bears the costs for prosecuting a matter. If you refer an infringement to court, then you are liable for the costs of the court hearing that matter. And it's a fixed cost. It's under a document called the Ready Reckoner, which is because matters will generally be referred to the Magistrates Court. So I understand for more than one offence, the cost is $129. For one offence, it's $85. So what magistrates will often do is if you refer a matter to court and you want to explain matters in mitigation, you say, yes, I was at this event, but I was there, because I care about the planet, because I want my grandchildren to have a life beyond, whatever matters you want to seek to raise. The magistrate might say, okay, well, I'm reducing the fine from $5,000 to $500, but you also have to pay the court costs of $123 on top of that. If you are defending a matter, you have a right to defend a matter. I wouldn't expect prosecution to apply for costs against you if you're found. They're not able to apply for costs against you if you're found guilty. If there's an adjournment of a matter that's occasioned without them being on notice, they might apply for costs of the witnesses attending on that day or something similar, but generally you're not liable for costs. Any assets that you may hold shouldn't be at risk. However, if you have things like mobile phones, items that might have been used in what the police say is the commission of an offence, for example, organising, messaging other protesters, the police could seize those and hold them while the charges remain before the court. And we often see that they essentially just take people's property, describe it as an exhibit, personal property being mobile phones primarily, sometimes computers, and then they hold that until the charges are finalised at the court. They can make applications for forfeiture if they believe something's a proceeds of crime or if it's been used in the commission of an offence. But if it was something an everyday object such as a mobile phone or a computer, I wouldn't expect the court to order forfeiture. I wouldn't expect that anyone's assets are at risk in a general sense, either, to answer that last part of that question.
The next question is about breaking bail conditions.
Yeah, so this is Victoria Police use bail conditions in a way that they shouldn't, and we've seen there's a principle at law that bail conditions shouldn't be more onerous than they need to be to ensure that the person attends court on the next date and doesn't commit offences in the meantime. What we see with Victoria Police is they will often, if you're arrested and charged, they will impose bail conditions. For example, not to associate with another member of Extinction Rebellion. In my opinion, that bail condition would never be imposed by a court. It's something that Victoria Police do because they can get away with it. Then they can say, oh, well, you've attended another meeting, it's a breach of your bail. Every bail that's imposed by police can be reviewed by the Magistrates Court. So there's often a delay in the procedure of the charges being issued against you, you being charged and then being listed with the court. And so it can be extremely frustrating. I've had people say to me, look, I've got these ridiculous bail conditions. I want to vary my bail. Let's go to court and do it. You only need to give 3 days notice. You have a right to do that. And then you go before a magistrate, talk about what bail conditions are appropriate. However, what often happens is the charges go missing. So the court hasn't initiated the charges. So there's nothing to put before a magistrate and ask to review your bail conditions. That's just a general comment with the system. What I would say is that bail is something that courts take seriously, even if it is imposed unfairly upon you. So I suppose you sign an undertaking of bail, it puts you in a position which is markedly different to just being an ordinary member of the community, because you now have positive obligations under that bail, and it's a legal document that you've signed with police. Police will often make threats when they're interviewing you, or if you refuse to sign bail, they'll say, oh, well, we'll just remand you in custody. They have to take you before a court as soon as reasonably practicable. So if you're not happy with the police bail conditions, you could potentially say, well, I'm not signing these, take me before a magistrate. However, the reality of that is it may well mean that you're in custody for a day or two before you can be taken before a court. If you do sign bail conditions, you have an undertaking of bail in your hands that will describe those to you. As a lawyer, I have to say it's still important to comply with those, because there are penalties for breaching bail. I think it's a 6 month maximum, 6 months imprisonment for a Bail Act offence. But if you're unhappy with those bail conditions, you do have a right to apply to have them varied by a magistrate. And you can make that application yourself with the courts, but it helps to have legal assistance because it's a bit of an arcane process.
Thanks, Tom. The next question is about rights. I'm not exactly sure what a designated event is. I think that was from Jeanette. Or designate special events.
Yeah, so I don't know if they would do this for XR events, but there's generally police have powers under the Control of Weapons Act to designate an area, and they will do this when they think there's a high risk of violent crime, or I'm not sure if it's related, if they have to specify that it's related to weapons. But basically, Victoria Police publish in the Government Gazette, they say a particular area will be a designated area for this date and time, and they have to specify the boundaries of the area and the time. What that empowers police to do is essentially walk up to any person who might be in that area, ask them to remove any face covering, ask them to search them and ask them their name without any probable cause, without any reasonable belief, that they might have committed an offence or are about to commit an offence. So I was trying to find out the other day, but I think there was a point during the lockdown protests where they designated the whole of the CBD. But it's rare, and generally you have notice. There's a notice requirement, although where there is a violent event, I think the Chief Commissioner or Assistant Commissioner of Victoria Police can also designate that area on the spot immediately, but it's very rare to see that happen.
Thank you. So the next question is about, it's a bit similar, maybe it's similar. Anyway, it's about being dual citizenship, and it relates to an Abbott government threat to deport dual citizens involved with terrorist organisations.
Yeah, this one might not be the best question for me. I don't do a lot of migration law. All I would say as a general comment is if you're still a citizen of Australia, you're still entitled to all the rights of being a citizen of Australia until, well, just full stop, I suppose. But it sounds like there are other issues at play there that I'm just unaware of, so I probably wouldn't be very helpful on that question.
Perhaps the other part of that question, though, is about XR being potentially designated as a terrorist organisation.
Yeah, I mean, that's an interesting question. It's probably more general political question. I don't know. I don't think we've seen that happen anywhere globally at this stage. But it's an ongoing question. Look, we've seen this authoritarian creep with this government, and nothing would surprise me at this point, but I would say that's unlikely in my personal opinion, but that's just one man's opinion.
So just back to this whole visa residency issue, do you think that arrest could impact on a citizenship application?
Yeah, well, so again, I'm not a migration lawyer, but I understand there's a character test applied during somebody's citizenship application. And so you are required to disclose whether you've ever been charged or convicted of a criminal offence. So that would be taken into account. It's really a personal question as to what your priorities are. There's no strict rules, I understand, about how that character test would be applied. Who knows, you might get a bureaucrat in Canberra who admires XR and believes, the climate crisis is our greatest existential threat and thinks that it's better to confer citizenship to someone who is a concerned person who exercises their political rights. You might get someone who says, oh, well, might run through a system that's completely blind to the nature of a charge and just, I don't know, makes it less likely to get citizenship. I guess the best answer I can give is I don't know, but it is relevant.
So the next question is about if someone has received a diversion after their indictable charge was dropped, can they request police dispose of fingerprints, and how to proceed in relation to that?
Yeah, I think the answer is yes. There's a limit on how long police can retain fingerprints on their file. I want to say it's 8 years or something similar, but that's something I'd have to take on notice, I think. Yeah, so I guess it might be a good opportunity to speak about diversion more generally. What I would expect is that anybody who's charged attending a protest event, if you don't have prior criminal history, then Victoria Police would say that diversion is a path that's open to you. In my experience, it's a fantastic opportunity to avoid progressing through the court system. If police aren't willing to issue cautions, diversion's the next best thing. So generally it requires someone to complete a diversion plan. It's generally only available once. I have seen people receive multiple diversions, but sadly it's something that's very arbitrary. It depends on the informant, the police informant who is the member who's laid the charges against you. If you have a sympathetic informant, they might issue multiple diversions. What it means is that the charge is diverted out of the court system. Once you complete this plan, there's no formal record in terms of publicly disclosable criminal record. So you've got a clean record, you're a clean skin. Any checks that employers or embassies do on your criminal record will come up blank. However, Victoria Police have their internal databases, and they have a record of when someone has received a diversion. Putting aside the question of fingerprints for now, I understand that the records held by Victoria Police don't have any limits in terms of how long they're in existence for. So they'll retain that record of you having been someone who's received a diversion into the future. But Serena, if I can take that one on notice as well, I'll have a look at that. There's a spent conviction scheme that's I'm hoping will be introduced soon. If someone does have criminal convictions, I think that the proposal is that if they're 10 years old and they relate to specific types of offences, minor offences, then we can finally have criminal records in Victoria sealed so that they're not disclosable. But at present, what you see sometimes is you'll come across people in the justice system who have, shop theft from when they were 14 years old, back in 1970 or something. It's still there on their record, and it would still be disclosed to an employer if they requested that record. There's no provision, there's no spent convictions legislation at present in Victoria.
Is that enough on diversion? There was a question clarifying diversion. Is that people comfortable with what a diversion is? Yep, I haven't seen any. Okay, cool. So now the question is about teachers who need to get a working with children and police checks and those sorts of things.
Yeah.
And presumably it might relate to other people with professional qualifications here.
Yeah. Yeah, it's a good question, and it's hard to give any really firm advice because each profession has its own professional bodies with obligations under the sort of umbrella organisation. Working with children's check is important. It's crucial to doing that role, and anything that puts it in jeopardy is a concern. I should know, but I don't know in terms of the working with children's check how charges affect that. I think they have there's ongoing sort of requirement to disclose whether you've been charged. I certainly know as a lawyer there's ongoing requirement to disclose. I assume that the same thing would be true of teachers within their professional body. And then it becomes a question of how that professional body deals with that disclosure, whether someone's their qualification might be suspended or something like that. I'm not sure. I'm probably not the best person to ask. In terms of working with children's check, I think any conviction or any court outcome is disclosed to them. I would not expect, personally, I mean, this is not particularly helpful, but I'd say I would not expect any charges from a protest event to impact whether someone is able to get a working with children's check. But this is probably very bad advice. It's off the cuff, and I think I would have to do some research to give a sensible response to this question. It's important that people, protect themselves and make sure that they don't put their livelihoods at risk. Coming back to that question of diversion, that's why that's such an attractive option if you have been charged, because what it means is that once the matter is diverted out of the court, that it's not something that has to be disclosed. Similarly, if you've been issued with an infringement, it's not a criminal charge. If you pay the infringement, the matter goes away. It's not on your record, doesn't have to be disclosed. So generally the way I suppose lawyers would deal with those things is to avoid having the charge enter into your criminal record. May well be that professional disclosure obligations mean that you have to notify even if you've been charged, and then continue to notify what happens with that charge as you move forward. But I'm happy to take that one on notice and try and get back to you as well on that one, Serena.
Okay. I mean, there are other questions that relate to this, which are about kind of local government code of conduct, working with hospital staff, requiring working with children checks.
Yeah.
I mean, it does relate to the employer or the professional bodies or the code of conducts, doesn't it?
Yeah, that's right. And so it's very hard to give general legal advice on that question, because it'll depend profession to profession and employer to employer. But, you know, I suppose it doesn't hurt for everybody to be aware of what their obligations are under their profession and what their rights are, you know, if you're participating in activist activities.
The next set of questions are about federal powers and the Australian Federal Police in Victoria. We have seen, I think maybe someone's here who's been perhaps approached by federal police outside a politician's office.
Yeah, right. It's an interesting question. It's very rare that I come across police power, federal police in my work. Generally, that relates to offences where there's sort of interstate or international criminal activity. I understand federal police have a remit, particularly in relation to federal politicians, the only police force in the ACT. So there would have been a lot of federal police involvement with XR over the past week. Yeah, it's a good question. I'm reluctant to say too much in response to it, though, because I don't know exactly what powers the AFP has in terms of day-to-day activities. I assume they would be similar to Victoria Police, but I'm reluctant to say anything on that. So I'm sorry, I should have probably prepared for that question, but I don't want to give any misleading information.
Okay, thank you. That's all right. You don't have to be perfect. So John Lorcan, do you want to ask a bit more about federal authorities' powers specifically?
There have been, since 2001, there have been draconian legislation at a federal level. I reckon they're able to whisk me away for a week or 2 weeks or 12 days or something, and my wife doesn't even know where I am, and she can't tell anybody I've been taken. Now, maybe these don't apply. I think that's my question. If I'm just a normal XR lightweight activist, what chance have I got of one of these unnamed variety arriving and doing something dreadful?
I don't know. It's I've never heard of it happening before. Hopefully that's some comfort. Generally, I haven't seen any federal powers used at protest events within Victoria personally, but I have limited experience. I know it is extremely concerning, the powers that the federal government keeps giving itself in relation to not having to disclose the location, essentially whisking people off as you described. But I would say its chances are very low. I wouldn't expect you to be at risk of anything like that. I suppose rather my focus is generally on courts in Victoria. So, you've raised a really good point about the general political conversation about what sort of powers the federal government has in relation to the individual. And, I share your concerns, but if it was happening that people in XR were being detained with those powers, I assumed that there would be a national uproar, or you'd hope that there would, but it'd be a general conversation within the political landscape. I've never seen it happen personally. I would hope that it never does in my lifetime, but I'm not surprised by the overreach of government powers at the moment. So I'm not sure how helpful that is. Again, this is probably, I think you'd probably need to be speaking to someone who specializes in Commonwealth powers, and I'm happy to ask around to see if we can find someone like that, but I'm hopeful that it won't be directly relevant to sort of Spring Rebellion events.
Thank you. So the next question is about international travel. So if you're arrested, charged, maybe worth a little tiny background just to go over the difference between being arrested and charged and that stuff, Tom? Because I think sometimes that gets
Yeah.
a bit muddled up.
Yeah, absolutely. So police have to tell you if you're under arrest, and they can only arrest you if they reasonably believe that you've committed an offence. When they do effect an arrest, doesn't mean that they necessarily have handcuffs on you. They can just tell you that you're under arrest. Then once you're under arrest, they have powers to search you, to require you to identify yourself. It doesn't mean that you'll be charged. There are rules about when Victoria Police lay charges, and there's a document within the police manual as to how they make that decision. So they can only lay charges if they have what they believe is evidence to support the charge and all the elements of the charge. If they don't have that, then their rule book says that they shouldn't be laying charges. Sometimes we see that they do, just as a way to control people, to put them on bail, those sorts of things. Generally, when their bail is imposed, there aren't conditions preventing international travel. However, sometimes Victoria Police will impose conditions to surrender your passport or not to attend any points of international departure. And obvious reason for that is because they want people to answer those charges, not to flee the jurisdiction. But in effect, those conditions can be queried by a court. Sometimes what you'll see is sort of a negotiation where you go before a magistrate, say, this person has bail conditions preventing them from traveling internationally. They have a sick family member in another country. They need to be with them. They will return to this jurisdiction, and the magistrate will say, well, that's fine. They can have their passport back if there's some other security, for example, a significant fine cash deposit or something of that nature that essentially gives the court comfort that they will return to answer those charges at a future date. But being on bail doesn't prevent you from travelling internationally automatically, unless that's a specific part of your bail conditions. Thank
you. How you going, Tom? You're doing pretty well there.
Oh, good. Thank you. Lots of curly questions, so it's good. I hope that it's helpful, but probably have to duck off in about 10 minutes or so. So
all right, let's just we've got a couple more things. So there's a question about being handcuffed without arrest. Is that within their powers? Is it okay?
No, I think what the police manual says is that they have to place you under arrest to restrain you, and so they would effect that arrest. I don't want to get this wrong. So under the police manual, in terms of when restraints are used, they, at the very least, they have to reasonably believe that you've committed an offence. And I think the rule is that they have to believe that restraint is necessary to prevent the commission of further offences. So, for example, if you're sitting in a roadway, if you're locked on or something like that, they may say, well, you've been given a direction to move on. You haven't moved on. You are now committing the offence of obstructing a roadway. You'll be arrested, and they would, if they place you in handcuffs, they would justify that by saying, well, it was necessary to restrain you to prevent further commission of the offence of obstructing a roadway. So generally, when police are putting someone in handcuffs, I would say that they would be under arrest, but I'm not sure if it has to be the case. So hopefully that answers that question, but it might be something where that might be a point that I need to come back to you on as well. It comes under the use of force provisions in the police manual. So that relates, I think, to capsicum spray. This might be a good point to talk about that. The police manual says all the force they use has to be proportional during a protest event. But sometimes what we see is them using force to disperse a crowd. That's contrary to what the police manual says. It's contrary to what the Charter of Health and Human Rights and Responsibility says. But we still see police doing that. And so whenever you see behaviour like that, where police are using excessive force, disproportional force, I would encourage protesters to be creating a record of that, and that can be fed through different channels in terms of how police are held to account. You can feed it back to Victoria Police themselves. Some people up the chain may be interested, and we have been successful in, particularly where police haven't identified themselves, encouraging directives that police must identify themselves. You can feed it through media channels, and that can often be very helpful. People are generally shocked at the way police behave if they haven't engaged with that sort of thing before. Or you can feed it to other bodies such as IBAC or political groups who may assist, or indeed you can feed that information to plaintiff firms which can help you with civil actions against police, such as Robinson Gill lawyers, other groups that can essentially take action if police have caused injury or caused injury, essentially. But yeah, in terms of whether you can be handcuffed or not, I would say on a personal level, if police want to handcuff you, they will, and they will make up whatever justification they want after the fact. Like I said, I've never seen anybody talk themselves out of an arrest. I've never seen anyone talk themselves out of being restrained by police. I have seen a lot of charges where people have been charged with hindering, and that's an interesting question, particularly where there's the use of non-violent resistance. Even people who are completely limp have been charged with hindering police in a duty or resisting police, and that's often a type of charge which is fought in the courts later on, and usually it's the police exhibits which will be the evidence which shows how someone responded to police conduct. So yeah, we often see police using those sorts of charges, even where someone is the exemplar of non-violent resistance and completely limp. Police will still find a way to charge them. Now, I don't say that to scare people, but just as a way of saying, look, police will do what they want on the ground, and then we often have to rake over the coals after the fact to sort out what's happened.
Thank you. So the next question is about, is it common to be arrested but not charged? And I would say yes. Do you want to comment on that, Tom?
Yeah, it's interestingly, it's probably an area I'm not very well qualified to comment on, because I usually see people after they've been charged. So my perspective's a bit skewed. And when I do attend protest events, I'm generally on the outside as a legal observer. So I see lots of, through the glass, I've seen people lined up under arrest, and then I assume a lot of them are released without charge. But I think many members of this group would be more qualified to answer that than me.
Do you want to comment on that, Rob? Are you still with us? No. Okay. So Rosie, do you want to briefly just talk about your experience with the Federal Police?
Yes, I with my husband, who's we went to outside Josh Frydenberg's office one evening, and just with stick chalk and started writing a message, and the two Federal Police officers burst out of his office, and one sort of shoved Richard to one side, one took me, and started being quite aggressive and intimidating towards us. We asked if we were under arrest. They didn't really answer the question. I was threatened with being handcuffed if I moved, because I wanted to get a bit closer to my husband. And they kept us there just with threats of arresting us with willful damage to Commonwealth property, et cetera, even though I said it was only chalk. But we were held. Eventually they called, the local police came and they just let us go. But, I put in a complaint because everything they did was completely wrong, I know. And I actually got a phone call from somebody who was quite, almost apologetic, and I think worried that I wanted to take further action. But, you know, I just made it clear that we knew that it was not on what they did, and said I didn't want to take any further action. But then I did write to Josh Frydenberg and with sort of a copy of my complaint, and said that because I asked the Federal Police Governor, I spoke to him on the phone, you know, it seems like, did Josh Frydenberg put you up to that? And they said, he said no, but it seems like a deliberate intimidation. And I said this and I wrote to Frydenberg. I said I was very concerned that it was deliberate attempt to intimidate and silence us. And then we weren't charged. It was during lockdown, but the Federal Police didn't say a word about lockdown. They weren't interested in that. And when the local police came, they said, look, we're not going to charge you. It would be pretty petty to charge you with lockdown offences. And they just let us go and said, please don't do it again. I think they felt we'd already put up with enough. But when we went and did some more talking with Brenda and Mark last night, the local police appeared. They said the Federal Police were waiting for us at Josh's office. We went up there, did some talking, and they just watched and were very reasonable and friendly and calm. So maybe they've got the message that, you know, to hold back a bit. Anyway, I don't know if that's relevant, but it was an interesting experience. And there were no witnesses, and passers-by were extremely, you know, aggressive towards us as well. So if they had started, you know, belting us up or anything, I don't think anybody was going to help us in Camberwell. So yes, the message there: always make sure you've got somebody to take pictures. This was we worked. It was a bit of a last-minute thing in the end, so that's why there were only the two of us. But we weren't in fear, but just really angry about what they could do.
Yeah. Well, I'm glad that they seems like your communication was effective, and I'm glad that last night they behaved more lawfully.
It's good to hear a good outcome, isn't it? In this crazy time. Tom, I'm aware that you've probably got to go pretty soon. So I'm just wanting to see if there's any other outstanding sorts of questions. I can't see anything else popping up.
All right.
Perhaps I'll say that I haven't got your email address, could you please put it in the chat? If I haven't already emailed you, I'm going to send out some handouts that Tom's sent, and I'll send out the PowerPoint, and there will be a recording available.
Fantastic. Yeah. What I've got before I go, I've got notes regarding this question of refusal to be photographed. I'll try and do some research on that. Destruction of fingerprints after receiving a diversion, and then probably more general comments about AFP powers of arrest. Was there anything else that I missed that the group would like me to try and do some research on? Did you have any other notes, Serena?
Oh, okay.
No, that's all. I put you on the spot, but the working with children check. Excellent, thank you. And Jeanette's asked that question about the fingerprints, so I'll try and get back to you. But I'd like to, thank you for organising this morning. I hope that it's been useful, and thanks again for rearranging things. I'm happy to chat to you all more again in future if that's useful, or I might be able to reach out and find another lawyer who's more familiar with a Commonwealth jurisdiction, which might be a good progression. So thanks all for attending. I hope that it's been useful, and good luck.
Thanks so much, Tom. Really appreciate your time.
You're welcome. Bye-bye.
Thank you.